Cynthia Anthony, Cynthia Anthony.
You may proceed.
Please the court, Ms. Drain. Good morning, ladies and gentlemen. Good morning, Mrs. Anthony.
Good morning.
Mrs. Anthony, do you recall several years back when there was an incident involving your son Lee going into Casey's room at night?
Objection, Your Honor.
Overrule at this point. Yes or no?
No.
Were you ever made aware that there were incidents of your son going into Casey's room at night?
Objection, hearsay. Call for hearsay response.
Sustained.
Did you ever have to deal with an issue?
Objection, may we approach?
You may approach. Objection sustained. Next question.
Mrs. Anthony, I just have a couple more questions for you. Do you recall testifying 6 months ago that you believed Caylee was still alive?
Yes.
Okay. Were you testifying truthfully at that time?
Yes, there was still a part of me that believed that Caylee was alive at that time.
And in January of 2009, you held a memorial service for Caylee Anthony.
No, it was February of 2009.
And you had requested that Caylee's remains be cremated.
Yes.
And approximately 1 year, actually 2 years later, you still held the belief that...
Let him finish the question. Don't answer the question, Ms. Anthony.
You still held the belief that Caylee was alive despite all of that.
Is there objection to the question?
Relevance.
Relevancy?
I think it's relevant to the case in chief, Judge.
Objection sustained.
Was your ability to block all of that out part of your faith?
Objection, relevance.
Sustained.
Mrs. Anthony, were you able to compartmentalize whether Caylee was alive or not for almost 2 years?
Objection, relevance.
Judge, that has direct relevance to Miss Anthony being able to do the same.
Sustained.
On August 14, 2008, ma'am, you went to visit your daughter at jail.
Possibly.
Okay. Do you recall seeing an evidence and also viewing a videotape in which you explained to your daughter that your husband, George, had blown up at the media?
I remember viewing the video. I'm not sure if that's the correct date, but yes, I remember the video.
Okay. And when you did that, there was an incident. Actually, you expressed that to your daughter, did you not?
Express what?
That your husband had just blown up at the media?
Yes.
And this was in response to a question that a member of the media had asked as to what his opinion was of the theory that Caylee had died by an accident.
Objection, hearsay.
Sustained.
This was in reference to a question as to an accident, was it not?
Objection, hearsay.
I'll rephrase, Judge.
Okay, objection sustained. You can attempt to rephrase the question.
Why did you tell your daughter about your husband just blowing up at the media?
Objection, relevance.
Relevancy?
Relevance, it goes to the actual way this child died. And knowledge, effect on the listener.
Sorry, questions from the media.
I'm not,
Objection sustained unless you can establish a foundation she actually witnessed and knows how the child died.
Mrs. Anthony, you expressed that this was a new theory, was it not? Did you not express that in the jail video?
Yes.
In fact, you said the latest story, the new theory or the new story is that Caylee drowned in the pool.
Yeah, let me clarify. It wasn't a new theory. It was the media's statement regarding that. It wasn't a new theory.
Right.
Didn't mean to answer that. Thank you.
In fact, a month earlier, on July 16th, is when you had told Detective Melich about that, correct?
On July 16th, I mentioned to him that I found the pool ladder attached to the pool.
And throughout that time, while you were being questioned by law enforcement, you had also told police about the pool incident or the pool theory.
Yes, I mentioned to,
Sustain as the leading.
Did you tell the police numerous times about the pool ladder and your pool theory?
relevance of her theory.
Sustain as to the relevance of dealing with theory. You can talk about what she told the police, but to a certain extent.
The statement on the jail video about this being a new theory is not true. It's not a new theory. You're clarifying it, is what I'm asking.
I said it's the latest story, I believe, from the media, or the theory from the media. It wasn't the latest. It wasn't the first time that we had discussed it with law enforcement. I was talking about what was portrayed in the media.
And Casey even said that after you had mentioned that George had just blown up at the media, Casey had even informed you, as what's in evidence, that she had heard. Correct?
She said she was aware that she had heard that her father had just blown up at the media.
And that wasn't true. That had just happened, correct?
I don't know if that's true or not. She could have heard it from someone in the jail.
You're aware that there are no televisions in the cells, correct?
I'm aware of that.
Okay. Now, I just wanted to clarify that out. There were numerous occasions where you had made law enforcement aware of the pool ladder incident, correct?
Correct.
And all of this information was being released in the course of discovery, was it not?
Object to the relevance.
Sustain.
I have no further questions.
Cross-examination.
Mrs. Anthony, good morning.
Good morning.
You recall when you related what the media was suggesting to your daughter, that her response to that was surprise, surprise.
That was regarding not her father blowing up at the media.
But the suggestion by the media that the pool had some involvement in Caylee's death, correct?
Correct.
The blowing up aspect of this exchange,
That last question, Judge,
Basis of objection.
calls for speculation. How does she know what the reason why my client made that statement?
Response from the state.
she was the individual who directed the comment at the defendant, and in context, the defendant responded. So the witness was explaining that the response was as a result of her comment about the pool rather than the comment about blowing up at the media.
Your Honor, my response to that would be that they're talking about the media. Surprise, surprise means the media is at it again, not necessarily that it was her thought on the process.
Objection overruled.
When you came into the Orange County Jail that day, you were upset as well because what the media was doing outside was suggesting to you that Caylee was deceased, correct?
Yes, the media was screaming at us and throwing out accusations like, what do you feel, how do you feel about your granddaughter drowning in your swimming pool? That was very upsetting.
All right. Because at that time, you believed that she was missing and alive somewhere else.
Correct.
Thank you, that's all I had.
Redirect. Ma'am, you may stand down.
Thank you, sir.
George Anthony, George Anthony.
You may proceed.
Yes, sir. Mr. Anthony, I want to pick up where we left off during your testimony for the state. Do you recall when I asked you about a statement you made on July 24th of 2008 in reference to your law enforcement experience where you stated, "We caught people out in the woods, in a house, and in a car"?
To counsel reading from a document that is not in evidence. This is not impeachment, this is not refreshing recollection.
Just bringing them up to speed of the questions.
Sustain, ask them a question, but don't read from the document that's not in evidence.
Do you recall the statement that we had discussed?
No, sir.
No, sir. Would it refresh your recollection if I showed you the statement?
Possibly.
You may.
I'd like to direct your attention to lines 1 through 5.
There's only one thing, sir, is I'd like to know what the question is prior to that, sir.
Do that. Do you remember making that statement, sir?
Absolutely, yes.
How did you know your granddaughter would be found in the woods 6 months later?
Objection, assumes facts not in evidence, move to strike.
I think all of those facts are in evidence, Your Honor.
The fact that he knew is not,
And I'm asking
and
you
I
how.
object.
Overruled, you can answer the question.
Sir, you're asking about my law enforcement experience when I was doing law enforcement, not anything about my granddaughter Caylee or anything like that, sir. That is taken out of context by you, sir. That is going about my experiences and what I knew of human decomposition and what it smelled like. That's what that's about, sir. You're taking it out of context.
Your question, your statement was in relations to smelling human decomposition in the woods?
Objection. This is not impeachment.
I'm not impeaching him, I'm asking him
And
questions.
I would object to a prior statement being read, relevance, not impeachment.
Approach and bring the statement. You may proceed.
Thank you, Your Honor. Mr. Anthony, did you tell the police that you smell human decomposition in the woods before?
Yes, sir. I had experience with that in law enforcement up in Ohio, yes.
Did you tell law enforcement that you smelled decomposition in a house before?
Yes, sir.
Did you tell law enforcement that you smelled human decomposition in a car before?
Yes, sir.
Now, getting back to the woods, the wooded area off Suburban Drive, during the months that Caylee was missing, you had actually walked that area. Did you not?
I didn't specifically walk in the woods. I walked a perimeter defense, and I can explain that if you'll give me a moment.
Please go right ahead, sir.
The reason why I did is because Sergeant John Allen came to my house with a stuffed animal of a cartoon character and asked if that had been in my home, if I had knowledge of that. And I told him no, and I asked him where he retrieved it from. He said at the end of the street. That's when I went for a walk.
And you were walking down that area during the 6 months? that
Sir,
she was
I
missing.
walked every street that I could in Orlando, specifically my neighborhood. Yeah, different times, sometimes to clear my head, sometimes to look up and ask what happened to Caylee, where she's at. Whatever I could do, sir, that's what I did.
Were you also not spotted in another wooded area?
Objection to the vagueness of the question.
Sustain, rephrase the question.
During that 6-month time period, were you in another wooded area, sir?
Objection to the vagueness of the question, other wooded area.
October of 2008, were you in a, not that wooded area, but a separate wooded area in Orlando?
Objection to some wooded areas may be relevant, some may not. Without specifying what area, the question is vague.
Overruled.
Sometime in October, we were finding another location for our command center, the Kid Finders Network, our tent, things like that. Yes, I was down at the corner of Hoffner and Lee Vista in an area that I had called about through the county commissioner's office to see if that was vacant and if we could utilize that for our nonprofit Kid Finders tent, sir. That's the reason why I was there.
Okay. And you were going to put up a Kid Finder's tent in the woods?
Adjacent to a street, sir, probably about 10 to 15 feet off the roadway, because there was a lot of activity, a lot of people coming by to draw attention to not only to my granddaughter being missing, but other missing children. That's what that was about.
Now, the statement that you made to actually, let me take back. On July 15, 2008, you actually, the first night that law enforcement came to your home, you actually pulled Detective Melich aside and you told him that the car smelled.
Not on the 15th of July, no.
The 16th of July.
Sometime in the early morning hours when he first had arrived, absolutely, sir, I did.
Okay. And you did that privately.
I can't remember if it was privately, if there were other officers there. We had numerous people at our home in the morning. Did I talk to him about the car, about an Amber Alert, about so many things at night to try to find my granddaughter? Absolutely. I was hysterical. I was upset. I wanted answers. I demanded those answers to come to try to find my granddaughter, and I would still do that today.
The night the police were called, you were hysterical and upset?
Yes, sir, I most certainly was.
Okay. Now, after Yuri Melich had gotten back with Casey, you also pulled him aside again, did you not?
No, sir, I didn't pull him aside, no.
Did you go to his car before he left and told him that something had happened to Caylee and that Casey was lying?
Specifics on what him and I discussed, if I'm not mistaken, at the end of my driveway, probably about 6:30, 7 o'clock in the morning, that we had been up all night. I know that I did talk to him and ask him what was going on, what was progressing, what information did he have. I did all those kind of things, sir, as a concerned father and a grandfather, because I wanted some answers, and I demanded answers from him.
And you told him that something had happened to Caylee and Casey was lying.
Sir, definitely something happened to Caylee. She's no longer with us. And Casey was the last one that I saw with Caylee. 1 and 1 adds up to 2, sir, in my mind. And no matter how you're trying to spin it, I'm upset because my granddaughter is missing. I don't know where she's at. I was told that someone had taken my granddaughter, forcibly removed her from my daughter, or my daughter dropped her off at some house. I'm trying to put all the stories and information together, sir. Was I running on pure emotion and drive and demanding answers? That is my right as a father and a grandfather, and as whatever you want to spin it. Was I upset and falling apart at the moment? Absolutely. My family was being torn apart. And for you to say that I was doing
I'm gonna
something
object
wrong,
to
sir, you're
to the
wrong.
witness commenting on counsel's questions.
Just listen carefully. Next question, Mr. Bass.
Yes, sir. Now, on July 24th, you went in and made this statement to law enforcement that you had smelled that car and you smelled human decomposition.
Yes, sir.
And you were sure of it.
I'm 100% positive.
Okay. And do you recall also telling them that Casey lives on the edge?
I possibly did. I don't remember the exact context. If I did, yeah, my daughter has a tendency to live on the edge. Yes.
Taking the statement out of context, not presenting the witness time, place, and persons present, and a chance to look at the statement.
Witness has answered that he recalls making that.
Anthony, did you have a full opportunity to answer the question as presented to you, sir?
I feel comfortable with what I said, sir.
Pardon?
I feel comfortable with what I said to Mr.
Okay,
Price.
thank you.
And you recall telling that law enforcement on July 24th, 2008, that Casey takes these lies as far as she can take them.
Objection. Time, place, persons present, and the portion of the statement.
Sustained, rephrase the question.
Do you recall telling law enforcement on July 24th, 2008, meaning Yuri Melich, John Allen, and Detective Shelley Mead, that your daughter takes things as far as she can take them?
Could I have page and line?
Page 29, lines 9 through 11.
Could I approach counsel and look at the context?
Yeah.
Objection, Your Honor. I'd ask counsel to read the question and answer in full under the rule of completeness.
I'm asking if he recalls making that statement, Judge, not impeaching him.
Your Honor, the rule of completeness, I believe, I don't want to make a speaking objection. The rule of completeness does require.
I bet you to do it on cross-examination.
Your Honor, if I may we approach, because I believe the rule
I know.
indicates it has to be done contemporaneously.
Mr. Baez, are you reading the whole question since I don't have the statement?
Yes, sir, I'll read the whole question.
Thank you.
Okay, I don't have the statement.
When asked, do you think the reason your daughter doesn't want to tell us what happened is for fear that what her mom might do, might say, "I told you so," or something like that? Do you think that it would be so disappointing to mom, and that's why she's taking this to the bitter end? And your answer was, "Now my daughter lives on the edge. You know, from all the lies, all the contradictions, and like my daughter takes things as far as she can take them."
If it's written down there, I said that, sure.
And in fact, during that whole interview, you kept talking about nothing but negative things about your daughter, weren't you?
Objection. The document speaks for itself. If counsel wants to put in for the jury to consider the entire statement.
I'm
for
asking-
For their own evaluation,
I'm-
the positive and negative, that's the appropriate way to do it.
I'm asking him if he recalls.
Overrule it, Mr. Brown.
Do you recall saying nothing but negative things about your daughter?
Apparently I did, sir. I was cooperating with the law enforcement any way I could to get some answers about my granddaughter.
And the very next day, you went and visited your daughter in jail.
That's possible. I'm not sure of all the exact dates. I know we didn't go as much as we wanted to.
And you've seen the videos of you seeing your daughter in jail, right?
Yes, sir.
You didn't say any of these negative things to her while you were visiting her, did you?
No, because I was trying to keep my daughter upbeat. I was trying to find out anything I could about where Caylee possibly could be. I was doing everything I could, sir, to keep her as happy and as comfortable as possible. I didn't want my daughter in there, but she is in jail.
The day before, you're throwing her under the bus with law enforcement, and the next day when you talk to her, you're being very nice, right?
Objection. Move to strike counsel's statement of his opinion.
I'll rephrase.
Sustained.
As you've testified, on the 24th, you're saying negative things about your daughter, and when you're on the video talking to her, you're saying nice things.
Again, sir, I was cooperating with law enforcement on one day, giving them information to help assist finding my granddaughter wherever she was at. The next day, going in and seeing my daughter, yes, I was trying to keep her upbeat because I don't want to see my daughter in jail, but unfortunately, she is in jail. And that's what you try to do. You try to talk to your loved ones, to your daughter, whoever it might be in there, to keep them upbeat so they're not in an emotional wreck when they're in a facility that they have no human contact with anyone.
So you were undercover of sorts.
No, sir, I was not undercover.
Argumentative. Move to strike.
Overrule.
You can answer, sir.
I was not undercover, sir. I was a father of a concern for his daughter and also for my granddaughter.
And you're aware that your daughter wanted to be bonded out, weren't you not?
Yes, sir. My daughter wanted to be out and try to help find her daughter. Yes.
And the reason she couldn't get bonded out is because you would not want to put up the house as collateral.
Objection. Relevance.
Sustained.
Move to strike.
Motion to strike, granted.
Now, on October 14th, 2008, you went and testified against your daughter, did you not, before the grand jury?
Objection.
Not asking him any statements he made, just asking.
Your Honor, the fact that a witness is subpoenaed and compelled to appear.
Approach. Objection sustained. Next question.
Now, sir, you testified that on July 24th, when you spoke to law enforcement, you had stated that you were, I guess just now, that you were 100% sure that you had smelled human decomposition in the trunk of your daughter's car?
Yes.
Okay. And you've testified to that in this trial a couple times.
Yes, sir. I'm not going to lie about that.
Okay. Do you recall giving a deposition, in this case, on August 5th, 2009?
It's possibly that was the day. I'm not sure. I've given a lot of information at different times.
You remember coming coming to the deposition?
Sir, whenever I've been asked to arrive somewhere, I've been there.
I was there.
If you're talking about August 5th, 2009, yes, there was.
Mr. Ashton and Ms. Drain Burdick and Mr. George were there.
Yes, sir.
And you were placed under oath,
Yes.
and it was the same oath you took today.
Yes.
Do you recall being asked a question? And did you believe the smell?
Objection. We have page and line.
Yes, page 220, lines 5 through 14. Do you remember being asked the question?
Give counsel an opportunity to defend.
And did you believe the smell? Did you recognize that smell as being the smell of human decomposition? And do you recall giving the answer, sir? Not human decomposition.
Objection.
I knew it was.
Objection. Rule of completeness, but it appears counsel is going to finish the answer.
Go ahead.
I knew it was decomposition there. I knew there was something that just didn't smell right to me. As I went around to the driver's side, opened the driver's door, it took my breath away for a second. It really did. I mean, it's 90 degrees outside. The car had been sitting there for over 2 weeks. So, sir.
Objection.
My que-
Under rule of completeness, I'd ask that counsel also read the answer at page 221, line 7 on the same subject matter.
I think
Read
that
it.
could be brought up.
Read it.
This is the answer to his question, sir.
Pursuant to 108.1, read the entire context.
I remember opening the driver's door, trying to vent out the car a little bit, and I remember it stuck the key in the ignition. As I did, I knew the car wouldn't start. As I told the guy, I said, well, it's probably out of gas. And the attendant that was there, he's the one that says, oh my gosh, this really stinks. And I said, yeah, let me stop. And then the question is asked, let me stop you for a second there. Well, do I have to keep reading other questions,
I
Judge?
request that counsel read through the answer which ends at page 22, line 6, because it is the same subject matter.
And I would request to conduct my direct examination and allow Mr. Ashton to do his cross.
Rule 1.8.1 requires it. Read it.
Okay. Let me stop. Then the next question is, let me stop you for a second before you go on to say to that. Okay. As you approached the car, did it come into your mind that the odor might be from decomposition of either your daughter or your granddaughter? Your answer, not at that point, sir. No, sir. It never crossed your mind? Mr. Ashton asked. Not at the initial point. No, it did not. Okay, go ahead. After I tried to start the car, I can remember the attendant saying how strong it was, and I said, yeah. I said, it's a little bit tough. I looked around inside the car. I couldn't see anything except my granddaughter's car seat and some shoes and other stuff. The car was messy inside.
I
Shall
would
I
ask the
continue?
counsel to complete the answer.
And I remember getting out of the driver's seat, walking towards the back of the car, and I didn't say it directly to this gentleman. I didn't say it underneath my breath. I said, please don't let this be my daughter or my granddaughter. As I opened up the trunk, the only thing that there was a bag full of garbage, a white bag and a tie on it, a twist tie. And there was an Arm & Hammer liquid detergent. I don't remember what size. I guess about the size, indicating there was a pizza box with maggots inside the box. I mean, in that bag, I remember that specifically because they were making a cracking sound like a hamburger on a skillet. I remember that specifically. I did not touch it. The attendant reached inside and says, this is your smell. He grabbed it, the trunk got shut, and walked over to dispose of it. Dispose of it inside the,
That's fine, Your Honor, that's the entire answer.
okay.
All right.
So, sir, do you recall testifying in your deposition that you did not believe that the car was human decomposition?
Sir, that answer, I believe, speaks for itself. I remember being asked about this at the very beginning, when I talked about walking up to that car and getting about 3 feet away from it, and the smell that emanated from that car. I could smell it 3 feet away on the passenger side. When I opened up that car door, yeah, it smelled like decomposition, human decomposition. I will clarify that. If I didn't say that exactly at that deposition, at that particular point, that's because, again, sir, you have to, when you relive stuff over and over again that is traumatic in your life, you try to give the most complete answer that you can. Was it decomposition to me? Yes. Was it not my granddaughter or my daughter that I found in the trunk of that car? No, they weren't there. But there is a smell of human decomposition in that car, not the garbage that was in it.
And you testified that on July 24th, you told law enforcement it was human decomposition. August 9th, it's not, it's the trash. And today, it's human decomposition.
Sir, I didn't say that it was the trash. I did not say that. There was trash in the back of the car. There was maggots and stuff like that inside of that box or that plastic bag that I saw. I have been completely honest with that, sir, about my feelings and what I saw and what I observed. I'm not making anything bigger than what it is. I'm stating true facts of what I saw, what I observed, and what I went through that day and what my feelings were. Neither my granddaughter nor my daughter were in the trunk of that car, and I'm grateful for that because I don't know if I could have dealt with seeing them back there.
Now, sir, the explanation that you give during your deposition is clearly the trash, is it not? Would you like to look at it?
Sir, there's also a difference between trash and garbage.
And there's also a difference, sir, of saying it's human decomposition and not human decomposition?
I didn't say anything about not being human. I said decomposition. I'm going to clarify that again. I think I've done that very well. You're trying to take this joy of my life away from me, sir, and you can't do it anymore.
Would you like to see your
I'm going to
statement?
answer this to you, sir. The decomposition that I smelled in the trunk of my daughter's car on July 15th, 2008 at Johnson's Towing smelled like human decomposition.
Would you
To
like
me, sir. That's what it smelled like to me. And my knowledge of law enforcement and what I saw for 10 years of law enforcement gives me that opportunity to know what that is. I can close my eyes at the moment, sir, and I can smell that again. How dare you, sir, try to tell me that I did something differently than what I did?
And that is why you called 911 right then and there, right?
No, sir, I did not call 911.
That's why you drove that car home.
Sir,
Argumentative, asked and answered.
you are arguing with me, sir. I'm trying to be
Sustain.
calm.
Rephrase your question, Mr. Bass.
And then you went to work, sir, did you not? After smelling this smell,
Objection, argumentative, asked and answered.
Overruled.
then you went to work, sir, did you not?
Sir, after I knew that it wasn't my granddaughter or my daughter in the trunk of that car, I did get the car started. I left with my wife. We took the car home. Was I concerned about what was there and stuff like that? Sure. But then again, my emotions were all over the place that day. Did I go to work? Yes. I also explained in different times that I've spoke to law enforcement, to the prosecution, to you and things like that, of stuff that I can remember and stuff that I experienced on that day. I know exactly what I did, sir, and I'm not ashamed of what I did that day. There's no
I'm gonna
reason
move
for
to
me.
strike non-responsive, Judge, to the question.
Overruled?
Now, Mr. Anthony, when you made this statement in your deposition, you were actually on a media blitz, were you not?
Objection. Vagueness of the word media blitz.
You were going on multiple,
Rephrase the question.
did you go on multiple media outlets and advocate the innocence of your daughter when you made this statement?
You're going to have to come up with dates, sir, and particular times and things like that.
August 2009, did you make any media appearances where you were advocating the innocence of your daughter?
Possibly I did, without seeing the context or things like that, sir. I didn't want to believe back then that my daughter could be capable of taking the life of her daughter.
Judge, I'm going to object to the non-responsive. I asked him a specific question. If he was on the media, making media appearances on behalf of his daughter.
The question was as to a specific purpose or opinion being expressed, and the answer is responsive.
Next question.
Now, sir, in late January of 2009, you attempted to commit suicide. Did you, sir?
Yes, sir, I did.
And you even left a suicide note.
Yes, sir, I did.
And you expressed some guilt.
Objection. The best evidence of the document is the document.
Sustained?
I have the original marked, Mr. Baez, if you'd like to use it.
You expressed some guilt, did you not, sir?
Objection. The document speaks for itself. The best evidence of its contents is the document itself, and I have no objection to its admission into evidence.
withdraw the question.
Sustained?
Were you hospitalized shortly after?
Yes.
And within a week, were you then again making further media appearances?
I don't remember what I did shortly thereafter being released from the hospital. Possibly I did. Not really sure.
And these media appearances that you were making them to advocate the innocence of your daughter.
Possibly without knowing exactly what was asked of me and how I answered that. I can't go back and say exactly what I said on that particular date and time, sir. I can't.
Do you recall being on 48 Hours?
Yes, sir.
And do you recall being paid $20,000 for that appearance?
You know, Mr. Baez, I have been nice to you. I have tried to answer every question to the best of my ability. And for what my wife and I might have retained from a news organization to bring awareness of my granddaughter, my daughter, and other missing children, that's what that article was exactly about. It had nothing to do with guilt or innocence or anything like that. We did that, sir, for self-preservations, to bring awareness for our children, for not only my granddaughter, because of how beautiful she was and the life that she meant to us.
I'm going to object to the narrative, Judge. Non-responsive.
Can response to the question.
Overruled.
I did everything that I could possibly do to bring awareness of what my granddaughter meant to me, to my wife, and to my son, and to anyone else in this world that fell in love with her.
Was that the focus of the interview, or was your daughter and her innocence or guilt the focus of the interview?
Unfortunately, it just seems like any time that any of the media came around to us, more focus was always placed on my daughter.
The focus of the media is not relevant to this
Sustained.
case.
And while you were advocating for your daughter's innocence, sir, did you make any appearances on the early show?
Possibly did, sir. I don't remember my exact itinerary or things like that. But then again, anything that we ever did media-wise was always to bring information about my granddaughter, other missing children, and I always spoke about that. I always did.
And all of these media appearances stopped when the allegations of abuse came up, correct?
I believe that, sir, was done through you, sir.
Sir, you recall finding out another way?
Objection. Relevance.
Please let me answer this.
Could we approach?
You may.
Mr. Anthony, you were questioned by the prosecutor in reference to ever molesting your daughter. Do you recall those questions?
No, sir.
You don't recall being asked by Mr. Ashton if you had ever molested your daughter?
You have to be specific, sir. When that might have happened, could have happened, you're not being specific, sir.
First day of trial. You were asked.
And a question, yes, sir, and I never would do anything like that to my daughter.
Okay. You know, of course, that sex with a child under the age of 12 years old is life in prison, don't you, sir?
Relevance.
Sustained.
You're aware of the possible penalties of child molesting, don't you, sir?
Objection. Relevance.
Sustained.
You, of course, would never admit to molesting your child, would you, sir?
Objection. Argumentative.
Overruled. He can answer the question if he can.
Sir, I never would do anything like that to my daughter.
My question is, you would never admit to it, would you, sir?
Sir, I would never do anything to harm my daughter in that way.
Only in that way.
Objection.
Sir.
Argumentative. Move.
Sustained.
Strike.
Now, sir, do you recall when we questioned you the first time in reference to the gas can?
Sir, I've been asked about those gas cans numerous times.
May I approach the witness, Your Honor?
You may.
So there's no misunderstanding of which gas can we're talking about, Mr. Anthony. That is your gas can.
What's the exhibit number?
Yes, sir. State's evidence 283. That is your gas can.
Yes?
And on June 24th of 2008, that gas can was missing,
Yes.
and you called the police.
Yes.
And you reported that gas can as stolen.
This gas can and another gas can that I had. 2 were taken.
And is that the first time you've ever reported gas cans stolen?
Yes.
And prior to that, you of course knew your daughter had used those gas cans many times to put gas in her car.
I had felt that way, asked her about it. Yes.
And you could even see the gas streaks on the side of the car.
Objection. Asked and answered in prior testimony. Repeating ground.
Overruled at this point, but let's get to the point.
If I had knowledge that my daughter had used this gas can or another one and placed it in gas that was inside of her vehicle, yes.
And do you recall in your testimony for the state, when I questioned you, you stated that that there was a gas can that you were shown in your deposition that did not have duct tape on it when you gave it to the police?
I don't believe I said that, sir.
Okay. Well, I'll ask you again, sir. When you gave the police that gas can, did it have duct tape on it?
Objection. It was given on 2 occasions. The council needs to specify which one.
Sustain, rephrase the question.
August 8th of 2008. The very first time they took those gas cans.
If I'm incorrect, counsel, it's August 1st. The
That's what I
photograph
said.
demonstrates that.
That's what I said.
I thought you said the
I
8th.
misspoke.
You said the 8th.
August 1st of 2008, sir. Did that gas can have duct tape on it when you gave it to the police?
It possibly did. I don't remember. All I know is they came to my home with a search warrant, and they took it from our father's shed that's on the south side of our home. I did not touch it at the time. They are the ones that reached in, said that this is what they were here for, and took it.
And that was after you told them of this alleged argument you had with your daughter over these gas cans.
That's not an alleged argument, sir. It happened.
That's after this. Well, there's no one else that can testify to this, right? Except you?
Oh, my daughter was there, sir. Her and I had a disagreement over the gas cans being stolen on the 24th. That's when I
Was there anybody
made a
else
report.
there besides you and your daughter?
myself, my daughter, and God knows the truth.
Okay. Now, anyone else on this earth, dog, anyone else you want to throw in there?
Objection, asked and answered, move to strike.
Sustain.
I'll withdraw it. Now, on August 5th, sir, of 2009, did you state, when asked the question, okay, when they took it, is it your,
Page and line.
yes, 208,
Please.
line,
Page,
9 through
line,
12.
Date, who was there, and then
Yes, sir.
give council an opportunity to define it.
208, lines 9 through 12. Do you recall giving a deposition on August 5th of 2009, sir?
If you're talking about the one that the state attorney's individuals were there and you were court reporter, yes,
Correct. All those people were there, and you were placed under oath.
yes.
And you were asked the question, okay, when they took it, is it your recollection that it had duct tape over the vent? And do you recall giving the answer, no, there was no duct tape on it on the vent? Do you recall giving that answer?
If that was at my deposition, sir, that's what I said.
And do you recall being confronted with a photograph, States Exhibit 107, of that gas can?
Briefly, yes.
Okay. May I approach the witness?
You may.
And do you remember, sir, being asked, did you take the duct tape and put it on and take it off again? And your answer, no, sir, I did not do that. And do you recall Mr. Ashton asking you, but is it your testimony here today, under oath, is that there,
Page and line.
same page,
What page?
lines 19 through 25.
What's the same page?
210, I'm sorry, Judge.
It's a different page. So 210,
Lines 21 through 25, actually. the next-
Mr. Bias, the jury can't see Mr. Anthony, so kind of reposition the gas can.
The question being asked by Mr. Ashton, but is it your testimony here today, under oath, is that you have a specific recollection that when the police officers took this from your home on August 1st, 2008, that piece of duct tape was not on this can? And your answer, uh-huh. And you were asked, please answer out loud, yes or no. And your answer was, it was not on the can. Yes, it was not on that can. Do you recall giving those answers, sir, under oath?
Yes, sir, I did. You just read them. Yes, I'll agree.
Do you recall whether they, when police took that gas can on August 1st, 2008, did it have duct tape on it?
Well, sir, if I'm going by this photograph, apparently it does. But also, if I might expand on this gas can was taken a second time, I believe, probably 10 days or so after that, for a second time.
You were asked specifically August 1st, 2008, were you not, sir?
Yes, sir.
And you were shown that specific photograph.
I don't know if I was shown this specific one at the prosecutor's office that day, at the state attorney's office. I believe, sir, I was shown a bunch of different things that day.
Are you trying to say now that you were shown a different photograph of another gas can?
Sir, this gas can is the only one that's ever been talked about. I know I was shown, at least I believe, to my best recollection, that I was shown another photograph of this particular gas can. So that's answering your question, sir.
Now, sir, I'd like to show you the certified copy of your deposition. May I approach the witness?
You may.
In the back of that deposition, sir, there are the exhibits. Do you see those tabbed?
Are you asking me to open this?
I'm asking if you see the exhibits attached to the deposition. You'll see a tab.
Sure, I see something. See, you're not being specific on what exactly, there's a lot of exhibits there. So.
Sir, I'm going to ask you the questions. I'm asking you first, one step at a time, if you see the tabs where the exhibits are.
Yes, sir, there's numerous ones here.
Okay. Every photograph that you were shown in your deposition is on on those tabs. Can you search through, and I direct your attention to tab 1 and 10. Let's go ahead and search them all and see if there are any other gas cans that were shown to you at your deposition.
I'm looking at number 1, and I just looked at number 10. It's the same thing that you just have right here.
My question to you, sir, is can you check them all and make sure that there were no other gas cans shown to you that day?
I just did. There's only the first exhibit, which is exhibit number 1, and exhibit number 10 have pictures of the gas can, or photos of it.
Okay. So according to your testimony in this deposition, either the police planted that duct tape on that gas can or you were not telling the truth.
Objection. Is counsel quoting the deposition? If so, it can't be paraphrased. Improper impeachment.
Sustain.
Can I have just a moment, Judge?
You may.
When you had this alleged argument with your daughter, did the gas can have duct tape on it then?
No, it did not.
So after Casey was finished with the gas can and she returned it to you, there was no duct tape on that gas can.
I believe I've answered that on a few different occasions, sir. The day that my daughter tossed those or set them down very aggressively on the ground at the rear of her vehicle, okay, and she said what she said to me.
I want to object to the narrative and ask that the witness be instructed to answer the question. It was a yes or no.
Overruled. He's answering the question.
Go ahead, sir.
The day that my daughter gave me back these gas cans on the 24th, that was an alleged argument. It occurred. And it weren't really too much of an argument at that time. Sure, there was, maybe the voices were a little bit loud, but when she put those down on the ground forcibly and said, here was my exact words were, here's my fucking gas cans. I've said that before. This particular can right here did not have the little white plastic tab, the air vent on top of it. It was not there. And I also believe I'm not mistaken is, did I put a piece of tape or something on it maybe eventually? Yes, I did, because anything that is volatile as gasoline, when it has fumes or something in it, can be a problem, and I didn't want that to occur. If I happen to put some kind of tape or something on it, maybe I did. I don't remember. And for me, and for you to say now that I put this on or what I testify to, sir, I'll agree with what's in here. I will. I'm not trying to be belligerent or.
Judge, I'm going to
I'm not.
object and object to the narrative and move to strike.
May the attorneys approach the bench along with the court reporter. You may continue.
Yes, sir. Mr. Anthony, I just want to clear this final thing up, if I may. When Casey gave you the gas can on June 24th, 2008, according to you, the gas can did not have duct tape on it.
That's correct.
And you have also testified when the police confiscated that gas can on August 1st, 2008, after Caylee was reported missing, that it did not have duct tape on it.
If I'm not mistaken, sir, that I have said when it was retrieved from the south shed of my house, I did not touch it. If there was duct tape on it at that point, possibly I had put something on it. I also said that when I retrieved that, when my daughter gave it from her trunk of her car in front of me.
Sir, do you
Sir,
understand the
I'm
question?
trying to explain, sir. I'm trying to explain your question. You're not letting me answer.
I would object, Judge, to the narrative. I asked him a yes or no question. If he testified that when he gave this gas can to the police, it had no duct tape on it.
Question calls for a yes or no answer, sir.
Did you testify to that, sir?
I'll say no.
You didn't. So did the court reporter get your testimony incorrect?
Objection, the document is not in evidence.
Sustained.
Do you recall reading in your deposition where you said it did not?
Objection, the document is not in evidence.
Sustained.
Did you testify that it was not in your deposition?
Objection, asked and answered. He said no.
Sustained.
May I read the question again to the court to impeach the witness, Your Honor?
Your Honor, the witness has been asked about the statement, has denied he made it, and I believe under 90.612 that is the questions that can be asked and the answer given. If we could.
Go ahead, Mr. Bass.
Thank you, sir. When asked, page 210, lines 5 through 11, for court and counsel.
Read the question,
Sure.
starting at line 3. You said page 210?
Yes, sir.
Question starts at line 3. And
Yes,
the
sir.
answer
Sure.
is from 8 through 11.
Yes, sir. Do you recall being asked, sir? Sure, and it is metal. So does it fall apart? All right. But is it? So it's your testimony now that when they took it on August 1st, that it did not have duct tape over the vent. And your answer, didn't have any duct tape over the vent. And when it came back to me, or the last time I saw it now, it had duct tape on it. It did, I did not put it on there. Do you recall giving that answer, sir?
I do now, yes.
And do you
Agreed.
recall being asked? But is it your I'm sorry, page 210, lines 22 through 25, through the next page through 10.
I believe counsel's already read that and the witness has acknowledged it.
Part of the impeachment.
20, excuse me, lines 22 through 211, line 1, the witness has already been asked and already acknowledged making the statement.
Sustained.
No further questions.
Cross-examination.
Mr. Anthony, on August 5th of 2009, you still believed that your granddaughter was killed by someone and it happened not in the custody of your daughter. Isn't that what you believed in August of 2009?
Yes.
And in that deposition, you and I sparred in much the same way you sparred with Mr. Baez here today.
Yes, sir.
And during that deposition, you were upset that you were being called upon to give testimony implicating your daughter in the murder of your granddaughter. That was your emotional state in August of 2009, correct?
Correct.
But today, you no longer believe that your granddaughter died in the custody of someone other than your daughter.
Judge,
Sustain,
You know, it goes to bias.
sustain.
When you when you were giving the statement on July 24th, 2008, that Mr. Baez discussed with you at length, did you ever tell the police that you thought your daughter murdered your granddaughter?
I didn't believe that at that time, sir. No.
In January of 2009, a month or so after you, let me strike that. You learned in December of 2008 that the remains of your granddaughter were found. Is that correct?
Yes, sir.
What effect did that have on you when you learned that Caylee's remains had been found?
A deep hurt inside. Tears. The whole gamut of just an emotional loss, a breakdown inside of me, and seeing what my wife and my son went through.
Up to that moment, had you held out the hope that Caylee would be found alive?
Absolutely. Every day from July 15th until the day we were told it was Caylee.
In January of 2009, you went, I'll give you a moment.
Need a break, Mr. Anthony?
No, sir, I need to get through this. I need to have something inside of me get through this.
Do you need a break, Mr. Anthony?
No, sir, I'm fine.
In January, just let me know when you're okay.
I'm okay, sir.
On January 22nd of 2009, Mr. Anthony, you went and got a gun, didn't you?
so
Counsel asked about this exact event.
Overruled.
Judge,
You may.
Well, I guess counsel should state the objection again. I'm not quite sure what the legal basis of the objection is. Counsel,
Yes.
is that counsel has had no good faith basis for asking such a question when he knows that there was no gun involved in this suicide attempt.
my understanding of the events of this date are that Mr. Anthony went and got a gun, that he did so with the purpose, I believe he will testify, he did so with the purpose of forcing people who he believed might know something about who killed Caylee, specifically friends or boyfriends of the defendant, with the intention of forcing them to reveal what they knew and then taking his own life. It is revealed in the suicide note, and I believe he will testify that that's what happened. The defense has brought up the suicide. I do, so the court knows, intend for him to identify his suicide note, and in my case, I do intend to offer it because it shows that on January 22nd of 2009, this man had no idea who killed Caylee Marie Anthony. And it rebuts implications by the defense that he did. It's directly contradictory to the defense's argument, and it is proof. And I do have case law when we try to admit the note, but at this point, the circumstances of the suicide were raised by defense counsel when he asked the question about that event, and I believe I'm entitled to go into that.
Let me see the suicide note and let me see the case law that supports your position. Share those sites with the defense.
I made copies for everyone. And again, at this point, I'm not offering the suicide note yet. I would be doing it in my case in chief, but. The cases would be Nelson versus Seaboard Coastline Railroad Company, found at 398 Southern 2nd, 980. I have copies for court and counsel. The other case is a case out of Louisiana, Court of Appeals of Louisiana, First Circuit, Garza versus Tau Delta Fraternity National, found at 916 Southern 2nd, 185. And I have copies for the court and counsel. Your Honor, that the gun incident is prior to the suicide, so I will correct that with the witness. I do want to ask him about it because it is mentioned in the suicide note at page 4. It does go to knowledge, but I will correct that point.
I will request that the question be stricken and the jury instructed, Judge.
That's fine. I'll just ask it a different way.
Okay, I've reviewed the State's Exhibit M.A. Suicide letter of Mr. George Anthony, and I've reviewed the two cases cited by the state of Florida. Mr. Baez, would you like a proffer of Mr. Anthony's testimony along this line?
I'm not exactly certain what the court's ruling. We are objecting to it, of course.
Well, what is the basis of, are you objecting?
To the admission, it's hearsay.
Which, his note,
I'm sorry?
the suicide note?
Yes, sir. And I don't think it falls under a dying declaration.
Mr. Ashton, your response as to hearsay?
It has two purposes, both to show the then existing mental or emotional state of the witness under
State of mind exception?
it is 90.803 3. And I believe that is the import of the Florida case I gave you, that a suicide note can be admissible to establish two things. The first is it establishes that at the time of January 22nd of 2009, it is significant that nothing in this document that this man wrote in contemplation of taking his own life, and he will testify that that was fully his intent, contains any statement of guilt or admission to doing anything to his daughter or his granddaughter. There's absolutely nothing in the note. So on the one hand, I would submit that the entire note is relevant because it does not contain. It contains many statements of guilt and regret for things that he has done wrong, but nothing about the particular offenses that the defense has accused him of in this case. On a separate matter, if the court does not admit the entire note, specifically page 3.
Let me see it, Madam Clerk.
Yeah. There is a specific issue raised in this case by counsel that Mr. Anthony knew in June of 2008 precisely what had happened to his daughter and where she was. The portion of page 3 that starts the following. She was so close to home. Why was she there? Who placed her there? Why is she gone? Why? For months, you and I, especially you, always questioned why. I want this to go away for Casey. What happened? Why could she not come to us, especially you? Why not Lee? Who is involved with this stuff for Caylee? Those specific statements show that in January 22nd of 2009, George Anthony did not know what happened to Caylee, how she died, or who killed her. It directly rebuts the implication by the defense, and it is admissible as a statement of then existing mental, emotional, or physical condition. Pursuant to the case that I've cited.
So it appears,
Mr. Byers?
it appears that Mr. Ashton is creating a self-serving exception to the hearsay rule, because that's all I heard as far as argument is concerned. And then he mentions that he was accused of something in June 2008. While that may be the theory of the defense, it was not brought out during any of the questioning of this witness. So I don't exactly, and again, that would still be self-serving. What is the purpose of this is to say he's innocent, and because he wrote it and took some some blood pressure medicine, therefore he can say he's innocent and a six-pack of beer. I don't think that.
The microphone is off.
That's completely the argument that Mr. Ashton said in his argument and appeal to the court.
Well, let me ask this question. You asked the question of Mr. Anthony. Did he attempt to commit suicide? Correct?
Yes, sir.
Did the state object? Okay. And what was the purpose, Mr. Baez, of asking the question about Mr. Anthony's attempt to commit suicide?
It's a fact in this case, Judge. He did attempt, however genuine an attempt it was, certainly that could be left for the jury to decide. Is this another plea for emotion? Could have been. Was it an outcry for attention? Could have been. Or was he really trying to take his own life? That, of course, only he can decide, or only he can say. But as to whether he has any, this gives him a free pass to write, I'm innocent, I'm innocent, I'm innocent, and go feel sorry for me because I drank a six-pack and some blood pressure pills. That I think.
Could it be that Mr. Anthony was so guilt-ridden that he wanted to take his own life?
Certainly could have
because
been.
he had molested his daughter, and that he felt that law enforcement was closing in on him? Is that one of the impressions that one could infer or deduct from the evidence? A counsel could argue from the evidence?
Among many others.
Generally, a witness's state of mind at a particular time is generally not an issue. And I think it's the Louisiana case that says it is very rare that it becomes an issue. It looks as though the defense has made Mr. Anthony's state of mind an issue.
I would add to that, Judge, that of course the prosecutor did not object.
No, he didn't object.
I was perfectly happy for counsel to open that door.
I,
Had no problem with it.
someone opened the door and Mr. Ashton's trying to walk through it.
I would submit, though, that Judge, even without that, his knowledge was an issue even before that. By counsel's other questions, particularly his implications based upon where Mr. Anthony said he had smelled dead bodies, all of those comments have implied from the beginning a knowledge of what happened to Caylee that is specifically rebutted by this evidence, by the portions I cited. I do think the entire note rebuts the general implication, which I'm sure counsel will argue before this jury, that this suicide was somehow guilt-ridden. In fact, he even asked the question, didn't you express guilt in the letter, to which I objected to best evidence. So it's clear why Mr. Baez wanted this before the jury, to imply that there's some guilt for the crimes that Mr. Baez has accused him of, and this letter specifically rebuts that implication. And I submit should be admissible in its entirety.
Anything else, Mr. Baez? Okay. Are you offering this now, or are you going to offer this later on?
Well, Your Honor, I don't think it would be appropriate for me to offer it in the defense's case, so my intention was to have him identify it and offer it in my rebuttal case, because I assumed the defense would object to my doing it in their case, so that's basically how I plan to do it. I do plan to ask him about his thoughts, his feelings at that time.
Okay. The reason I asked, Mr. Baez, you're not going to let him introduce it in your case, are you? Okay. As long as that's what you're going to do, I think the door has been opened, but I really want to have some time to contemplate and read a few more cases in this area. But it is fair game on cross-examination to cross Mr. Anthony concerning the suicide, which was brought up on the direct by the defense. Okay, y'all need a quick 5 minutes before we bring this jury back in, because we will be forging ahead, and
Yes, sir. Just
Until
a
noon.
comfort break would be nice.
I just wanted to make sure you weren't trying to do it now. That would mean that I would have to
My intention was to
Not-
do it in my case.
have a bite to eat, but study during the lunch hour.
I understand. Yeah, if we could take a 5-minute break, that would be it.
We'll take a 5-minute comfort break until 11:30 for the staff. Did you want a proffer of Mr. Ashton's cross-examination?
Sure.
Okay.
Require me to proffer?
Yeah.
All right. Mr. Anthony, in August of 2008, you went and obtained a firearm, did you not?
Yes, sir.
Why did you obtain the firearm?
Two reasons. Number one, I wanted to go get answers that I believe I could get from individuals that I felt in my mind at the time was responsible for Caylee.
You were going to force them at gunpoint to tell you information that you thought they had about what happened to Caylee based on what your daughter had told you.
Yes, sir.
What happened to that gun?
When I had retrieved the gun up, I think after about 2 or 3 days before I was allowed to take it out of the gun shop, an evening, I believe it was probably the 2nd or 3rd of September, I'm not really sure of the exact date, the sheriff's department and I believe a lady from the corrections department or something of that nature came to our house, came to Cindy and I's house, and because my daughter was home, told me that they had found out that I had purchased a firearm, and that was in violation of a firearm being in the home or alcohol being around someone who's incarcerated at my home, and the gun was taken from my car.
Before you had a chance to use it for the purpose you intended?
Yes, sir, was still had all the proper locks and mechanisms on it and things like that, yes.
Now, on January 22nd of 2009, you went to a hotel in Daytona Beach with the intention of taking your life.
Yes, and I still have those feelings every once in a while and even today.
Did you put pen to paper to leave an explanation for your wife and your family as to why you had chosen to take your life?
Yes.
May I approach the witness?
You may.
Show you state's exhibit. Actually, this is marked. This says defense MA. Is that correct? I mean, state's MA, I'm sorry. Is that the note that you penned on that day?
Yes.
Is that a true and accurate statement of your thoughts, your feelings, your intentions, and your knowledge as of that date?
Yes.
Had you also sent some text messages or communications to friends, family members, or your lawyer about what you were doing?
I know that I had sent text messages as far as what I exactly said, but I also know that I called my family, my sisters, my mother and father, basically to tell them goodbye, even though I didn't say that. I just told them not to worry. I wanted to go. I needed at that time to go and be with Caylee.
And you expressed that in the note.
Yes, I did. Because I
And-
believe I failed her.
Were you prevented from accomplishing your goal by the intervention of law enforcement?
Yes, if it wouldn't been for law enforcement, I wouldn't be here today.
That is a proffer of the testimony on those issues that I would offer.
Okay. All right. You have an objection to the testimony, Mr. Baez?
Oh, I'm sorry, there's one other I
Okay.
would add, just to be safe. Mr. Anthony, in that note, did you express some of the unanswered questions that were in your mind about what happened to your granddaughter?
I know I did. I don't know exactly what I wrote at that time. I do know that my penmanship throughout, at the beginning, at the end, I wrote it over many hours that night.
Those would be the questions I would ask.
Okay, any objections to that testimony, Mr. Baez?
Much of it is beyond the scope of direct examination. I certainly don't see the bearing of the firearm. None of that was testified to, and none of that has anything to do with this.
Witness about his knowledge during the periods of July, August, going into January. This is direct rebuttal to the implications of counsel's questions about this witness's knowledge of the fate of his granddaughter.
Ask that counsel point exactly to which question he believes, because I don't, or I don't know what he's talking about.
I rely on the court's recollection of the testimony on direct.
I think your microphone is off.
Yes, sir, I could cover the areas that I spoke with him. That was the areas of decomposition, his behavior with law enforcement at first, then his behavior on the jail video. Then I questioned him about his financial interests, his media appearances, his abuse, and his knowledge of duct tape and the gas can.
Questions were not limited in date or scope. Mr. Baez's questions covered a broad range of dates and topics.
Okay,
Mr. Ashton just finished making.
well, the subject matter of the cross-examination deals with the issue of Mr. George Anthony's attempt to commit suicide. The issue of suicide was brought out in the defense's cross-examination of Mr. Anthony. Those questions are a logical progression dealing with the issue of suicide and the fact that the gun has some relationship to all of that. So the court will permit this line of questioning. As I said before, you can mark and have him identify the note. As you know, until it comes into evidence, you can't question him about the contents of the document, and the court will take this under advisement and look at this issue. Okay, let's return to jury. Stay recognized, President of the jury.
Yes, sir.
Defense, you may continue.
Mr. Anthony, in August of 2008, did you purchase a firearm?
Overruled.
Yes, I did.
What was your purpose in purchasing this firearm?
I wanted to get answers from people that I believed were involved with my granddaughter missing.
These were friends or associates of your daughter that you felt had some information that they were not giving up.
Yes,
And you were going to use that gun to force them at gunpoint to tell you what happened to your granddaughter.
Yes.
Now, before you had a chance to do that, it's correct, is it not, that law enforcement learned that you had obtained the gun?
Yes, law enforcement had found out from, I don't know who, and law enforcement came to my home with someone from, I believe it was the corrections department, I'm not really sure it was, and advised of the violation of a court order that a handgun and or alcohol are not allowed inside of our home when our daughter is there.
And since your daughter was home on bond, you were not permitted to have a firearm in the house.
That's correct.
And did they take the firearm?
Yes, they did. They had taken it the same day that I had brought it home. It was in the rear trunk or rear spare tire area of my vehicle.
So you never had a chance to use it for its intended purpose?
No, sir, did not. When I brought it home, it still had all the proper cables, key locks, and things like that. No, sir, I never did.
Now, on the 22nd of January of 2009, this is approximately 6 weeks after the remains were found, did you travel to a hotel in Daytona Beach for the purposes of taking your own life?
Yes, sir.
Why, on that particular day, did you decide to take your life?
Why that particular day I picked out, I really don't know. All I know is my emotional state, even through today, is very hard to accept that I don't have a granddaughter anymore. But for that particular day, I don't know, it just felt like the right time to go and be with Caylee.
Did you call relatives and, perhaps not literally, but say your last goodbyes to them?
Oro,
I wanted to talk to my parents, my sisters. I know I called my son and my wife, and just somehow I was okay. Yes, to say goodbye for the last time.
Did any of them try to get you to tell where you were? Do you remember the content of the conversations?
No, because really, I was supposed to be going to a meeting that day, and I don't know, I just decided that was the time for me to get away from all this, to spend time with Caylee.
As you sat in that motel room in Daytona Beach, did you put pen to paper and write a letter to your loved ones?
Yes, I did. And the letter itself, through drinking alcohol, taking pills, I started out to talk. I wrote this specific letter to my wife, Cindy, and just to tell her how I felt and how I didn't want to be in this world anymore.
Did you include in that letter questions that you had about what happened to Caylee?
Absolutely, exactly what I said in that letter, I really don't remember because I never really looked it over. All I know is there was numerous pages I wrote, and I know that my penmanship and stuff, I probably repeated myself numerous times, and all I know is I had to express what I was feeling and not feeling.
You wanted Cindy to know why you would be dead when she found the letter. Is that a fair statement?
Yes, because I couldn't tell her face to face.
May I approach the witness?
you may.
Show you state's exhibit for identification MA, composite exhibit of positive 8 pages. Tell me, sir, if you recognize that as the letter that you wrote to your wife and family as you were preparing to take your life.
Yes, this is This is definitely a letter I wrote to Cindy and my family.
Thank you. May I approach and retrieve the exhibit, Your Honor?
You may.
Mr. Anthony, but for the intervention of law enforcement, you would not be here today, would you, sir?
Judge,
Basis of objection.
relevance and asked and answered.
As they asked and answered, sustained, he's answered that.
In the proffer he did, Your Honor, I haven't asked him that in front of the jury.
Yes, he has, Judge.
If you'll look back and review, I think you'll find that
He can answer it.
that's correct, is it not?
Yes, that's correct.
No further questions.
Redirect on those issues.
Do you need a break, Mr. Anthony?
No, I'm fine.
Mr. Anthony, Mr. Ashton questioned you about sparring with him at the deposition. Is that correct? Do you recall that?
Yes, sir.
And this sparring even had Mr. Ashton questioning your truthfulness, did he not?
Objection to counsel's expression of his interpretation.
Sustain.
I move to strike.
Motion to strike, granted.
Do you recall Mr. Ashton reminding you of your oath, sir, during the deposition?
I'm sure he probably did, sir. I don't remember exactly that day.
And this sparring that went on was to try and pin your answers down on these gas cans, correct?
Objection to his conclusion about my intention.
Sustain, rephrase the question.
The questions had to do with the gas cans and the duct tape, did they not, sir?
I know there was some conversation that we had throughout the whole thing. I know there's different times we talked about specific things, gas cans, duct tape, my granddaughter, my daughter, a big gamut of things.
But the issues where you were sparring with Mr. Ashton about related to the gas cans and the duct tape, did they not, sir?
Well, to clarify sparring, that can be looked at two different ways. I mean, was there a verbal talk, him and I going by, I could just consider verbal sparring? Yeah, I guess that would be considered, yes.
Now, Mr. Ashton classified my questioning with you about the gas cans and the duct tape as sparring. Would you classify that as well, sir?
Yes, I would.
Now, when you got that gun in August of 2008, your daughter was out on bond.
Yes,
She was under house arrest.
yes,
And the first day that she came home, you, the entire family, met with a person from the Department of Corrections having to deal with house arrest.
yes,
And they explained to you the rules of someone being under house arrest, what you can't do and what you can't do, or what you can do and what you can't do.
correct.
And you were even given a list of what could be in the house and what couldn't be in the house.
Correct.
And on top of that, sir, you knew that you couldn't have firearms in that house.
Correct.
And you knew if a firearm was found in that house, that Casey would have to go right back to jail.
Correct.
And in fact, when they caught, as soon as you drove up, within hours, Department of Corrections was there.
Correct.
And they almost took Casey right back to jail, didn't they?
Yes.
You never, prior to Casey being out on bond, went out and bought a gun, did you, sir?
Sir, My emotional state when I purchased that gun was to go get answers about
Sir, I'm
my
gonna-
granddaughter, sir.
Judge, I'm going to object to being non-responsive.
Listen carefully to the question, Mr. Anthony, and answer the question.
My question to you, sir, is before your daughter got out on bond and had those conditions, you never went out and bought a gun.
No, I didn't.
This attempted suicide that you had, you went out and bought a 6-pack of beer. That was the alcohol you were drinking, right?
I don't know how much I purchased at that time. No, I don't remember that.
Was it a 12-pack of beer?
I don't remember.
Okay. It was beer.
Yes.
Okay. And the pills that you took were blood pressure medication, were they not?
Oh, there was a lot of different stuff that I'd taken with me, sir, that I just had gotten probably a week or so prior to that from a physician.
So you were drinking beer and blood pressure medication?
Sir, I had all different kind of stuff involved as far as nerves, something to keep me calm, whatever it was. I took a large amount of medication along with drinking beer.
Do you know what was recovered from your hotel room that evening?
You know, sir, I do not. I don't have a list in front of me. I have no idea.
Now, all of this was subsequent to 2 search warrants being issued at your home, correct?
Are you talking a specific date, a
Yes,
time?
I'll go back and explain. You had a search warrant issued on your home December 11th, 2008.
As far as I know, I did, sir. I wasn't there to accept it.
You had another search warrant issued, well, let me stop there. The search warrant of December 11th, 2008, law enforcement went through a lot of your things, did they not, sir?
Sir, they completely went through the whole house.
My question to you, sir, is they went through a lot of your things.
Sir, everything inside that house I have knowledge of. I've either purchased it or something. Yeah, it's my stuff. It's my stuff.
Specifically things that would be associated with you.
Everything in that house is associated with me.
I'm talking about your car,
Sure, my car is in the garage.
and they went through it.
Yes.
And you know that car was not in the search warrant.
Objection to relevance of whether it was in the search warrant or not.
Think.
Overruled at this point.
You know your car was not listed on that search warrant, right? And they went through it anyway.
Right, the whole house was turned upside down.
And they went through a lot of your personal things, not Casey's.
Sir, I wasn't there to see the search warrant. They went through the whole house.
And then they confiscated that gas can on December 11th.
I don't know. I don't know. I have no idea.
You were given a property list of what was confiscated on December 11th, were you not, sir?
As I've stated, I was not there when the search warrant itself was served on our home. I was not there. And exactly what was taken all the time, I do not have that much of a detailed memory to know exactly of, I believe it was like 70 or more items that were taken from our home.
And you're an ex-police detective, sir. You know that after executing a warrant, the warrant and all property taken is left at the home.
I would believe so if it was given to our attorney. I don't know what was all left behind. All I can tell you is our home was turned upside down.
And included, what they took was the duct tape on that gas can, correct?
Like I said, sir, I don't know exactly everything that was taken from our home. I've answered your question, sir.
All right, let me ask you this way then, sir. When you came back from doing the Larry King show in California on December 11th, and you got into your home, did you see that gas can ever again in your home?
Well, sir, I never came back home to my home on December 11th, 2008.
Whenever you came back home, sir.
I'm answering your question, sir. I did not come back to my home on December 11th, 2008. I did not.
December 15th, whenever you came back.
Sir, I don't remember exactly what time we came home, what time. or anything like that. I've said this, and I'm going to say this again for probably about the 10th time, and I'm not trying to get upset, but you're making me upset. I can tell you right now is our house was in shambles. Our house was turned upside down. Things were flipped around our house. It took us days.
Judge, I'm going to object to the narrative.
Get it
I've
cleaned
asked
up.
him a specific question. He's refusing to answer it and giving a narrative.
Overruled.
Okay. Mr. Anthony, you came back and you didn't go directly to your home. You went to the Ritz-Carlton, correct?
Sir, there was arrangements made for Cindy and I, yes.
Okay. And you stayed at the Ritz-Carlton for a couple of days.
Possibly, I'm not sure how many days it was.
Relevance of where they stayed.
Sustained.
Then you came back home before the second search warrant was executed.
Yes, sir, because I was there for the second one.
Okay. And you did not see that gas can or the duct tape in your home then, did you, sir?
On that particular date, on whatever day that was, I don't remember. I don't remember.
And you had in your possession all of the search warrant that was issued on December 11th, as well as everything that was confiscated during the first search warrant.
Sir, I don't know of all the, like I said, I know there was over 70 items taken.
My question
From
to you,
our
sir,
home.
is you had in your possession the items that were taken and the search warrant before the second search warrant was issued.
Objection to counsel's vague question, items, what items?
The property list.
Sustained, rephrase the question. It's 12 noon now. So
Yes, sir.
we're gonna break for lunch. They have some place.
Sure. Oh, I'm sorry.
And I have another matter at noon.
Yes, sir. I apologize.
Okay. All right, we'll be in recess for lunch. Please remember all of my previous admonitions. Is candidate upstairs yet?
Sir, we do.
And members of the jury, did you heed all of my previous admonitions during the recess? Mr. Baez, you may continue, sir.
Thank you, Your Honor. May it please the court. Mr. Ashton. Good afternoon, ladies and gentlemen. Good afternoon, Mr. Anthony.
Hello.
I think where we left off, sir, was you had just gotten back from the hotel and you were at your home. And on December 20th, they issued a second search warrant of your home. Do you recall
Yes.
that?
Yes.
And you were home that day.
Yes.
And you got confrontational with the officers.
Yes.
And in fact, you had to be removed and sent to the back of the house to wait outside.
I was asked to step outside.
And you told Sergeant Allen, page 79, line 17 and 18 of Detective Allen's deposition.
Sorry, counsel wants to quote from someone else's deposition?
No, I'm going to ask him a question, if I may.
Oh, certainly.
You told Sergeant Allen, take your fucking minions and get out of my house.
Objection. Relevance.
Goes to the line of questioning, Your Honor.
Relevancy?
Goes to this individual's state of mind prior to committing or attempting to commit suicide.
I'm sorry, Judge, the date, I think it's the 20th. This is a month before.
There's a series of
Suicide.
events that occurred prior to that, Judge.
Objection sustained as to that question and comment.
They then confiscated further materials, did they not, sir, from your home?
Yes.
And the next thing that occurred in this investigation was the state attorney's office issued a subpoena for your fingerprints.
Probably, excuse me, probably happened right around that time.
From counsel for that event?
Do you recall, sir?
Rephrase the question.
Yes, sir.
Put a time period in it.
In December of 2008, do you recall the state attorney's office issuing you an investigative subpoena for your fingerprints.
I'm sure they did. If it happened in December of '08, it possibly happened. I don't remember the exact date, but probably was.
And how many times have you had an investigative subpoena from the state attorney's office issued to you, sir?
Relevance.
Relevancy?
It's a significant issue in his life, Your Honor, a significant event.
Objection sustained.
That is not something you provided voluntarily, is it, sir?
What is that, sir? What are you talking about?
Your fingerprints. That is not something you provided voluntarily. They had to issue a subpoena for you.
Yes.
This is also approximately when, in December of 2008, or shortly in early January 2008, is when the video surfaced of Dominic Casey and Jim Hoover searching in the wooded area. Is that correct?
That's a possibility. I don't know the exact time.
Now, you at this time had noticed this video and become aware of it. Did you ever ask Dominic Casey what he was doing there?
Objection. Point in time, vague question, and hearsay. And relevance.
Rephrase your question as to time.
Yes, sir. In January, early January 2009, when this video first surfaced, did you go to your investigator, Dominic Casey, and ask him what he was doing in the woods?
Objection assumes the fact not in evidence that this video, quote unquote, surfaced in January of 2009.
Overruled, he can answer the question if he can.
I didn't know anything about a video being shot until it was released.
Which was early January 2009. Do you not recall, sir?
If that's when it happened, sir, then that's when it is. I don't really remember.
So my question to you is, did you go and ask Dominic Casey what he was doing in the woods?
No.
They had just found your granddaughter in that same vicinity, did they not?
I was told that in December, but I did not get that information from Dominic Casey. I didn't have a conversation with him on that.
Have you ever had a conversation with Dominic Casey asking him what he was doing in the woods 1 month before Caylee was found?
No, I never have.
Never sparked your curiosity?
Asked and answered.
Sustained.
After all of these investigations and search warrants and the subpoenas, sir, in early January of 2009, did you feel the walls closing in on you?
Argumentative assumes facts not in evidence.
Overruled.
I don't understand your question, sir.
You knew you were being investigated, didn't you, sir?
Objection assumes fact not in evidence.
He asked for clarification, Judge.
There's no evidence that Mr. Anthony was being investigated.
I think we heard evidence by the answers.
Rephrase your questions.
The pressure was getting to you, wasn't it, sir?
Objection. Leading. Argumentative.
Was the pressure getting to you, Mr. Anthony?
Objection. Argumentative.
Overruled.
From the beginning, July 15, 2008, I have always cooperated with any law enforcement, any FBI, any Florida Department of Law Enforcement, with you, sir, even, anyone that I could get information about my granddaughter or help in any way to bring her back home. I did that.
All of that cooperation ended on December 20th when you asked sheriff's officers to leave your home, correct?
Well, sir, I've answered this question numerous times, and I'll answer it one more time for you. The loss of my granddaughter, when I first knew that she was missing, and the ultimate time it was found out that she was no longer with us, that was a tumultuous time in my life, my wife's life, my son's life, and everyone in our family's life to lose our granddaughter and a potential to lose my daughter.
My
over this.
question, sir, was all of that cooperation ended on December 20th, 2008, when you instructed the police officers in a not so polite manner to leave your home. Isn't that correct, sir?
I was upset that day, sir. I was very upset. I have every right to be upset that day.
Did you understand my question, sir?
Yes, sir, and I've answered your question. I was upset that day.
So from there on out, you stopped cooperating once you found out they were investigating you.
Sir, there's been so many people been investigated because of this, besides myself. And I have opened myself up for every part of the investigation. I have nothing to hide.
Is the answer yes or no, sir?
If you'd like to ask me if it's a yes or no answer, I have completely cooperated, so that would be a yes.
Now, prior to this suicide, you were, the day of this attempted suicide, you were calling everybody to let them know you were going to commit suicide.
Objection, leading.
Sustained, rephrase the question.
You called many, many people, did you not, sir?
Yes, I did.
You even called me.
I probably did. I don't remember if I called you or not. I probably did.
You wanted everyone to know long before you were about to attempt to commit suicide that you were going to do it.
Objection, leading, argumentative.
Sustained,
As to leading, sir?
argumentative.
And after this alleged attempt, sir, you immediately left the hospital and went to Putnam County to be on television, did you not, sir?
No, sir.
Did you not go and have several media appearances shortly within 24 hours of leaving the hospital?
Not from leaving the hospital, no, sir.
Did you have, well, how long before you went and made media appearances?
If you can give me a particular date or an incident you're talking about, sir, I can probably give you all the information you want.
Sure, January 22nd is the day of this alleged attempt, is it not?
Well, sir, it wasn't an alleged attempt. It was an attempt on I tried to take my own life. So
Okay.
that's not alleged. That happened.
Okay, now, after that date, when's the next time you were on Fox News?
I have no idea, sir. I have no idea.
Was it within 48 hours?
I don't believe so.
And answer, Judge.
Sustained,
I have no further questions.
Just a couple more, Mr. Anthony.
You traveled to California with your wife to be on a national show hosted by a gentleman by the name of Larry King just before the remains were found. Is that correct?
Yes.
And in fact,
I'm going to object. This is beyond the scope of redirect. He's discussing issues of December 11th,
counsel
or
specifically asked
December
about
10th, I should say.
Larry King.
overruled.
And the purpose of that media appearance was to publicize the disappearance of your daughter and the plight of other missing children. That's what you talked about.
Well, the disappearance of my granddaughter, yes, and how it's affected our lives.
And did you learn of remains being found before you left California or when you arrived?
In the morning, just prior to boarding our plane, we had gotten phone calls. I can't remember if it was Mr. Baez or not, or the Sheriff's Department, or a conjunction, one right after the other, but Cindy got some calls, and they had found a small child.
When you arrived back in town, you were whisked to the Ritz-Carlton, correct? Someone
Yes,
picked
yes,
you up
sir.
and took you
It
there.
was, when we arrived, within probably an hour after we had settled on the plane, we were taken to eventually what I saw was the Ritz-Carlton, yes.
You didn't arrange that or request that. Someone had done it on your behalf, and you were taken there.
Yes, we were taken there, yes.
Did you have at least a small window of privacy with your wife to deal with the news that you had just heard?
On our plane ride back, we did have a little bit of time wondering what was going on. That's a 5-hour flight. When we arrived and we were told we couldn't get off the plane till everyone was off of it, and we had Orlando Police Department, a numerous amount of people holding us back to get off. The only time that Cindy and I could really comprehend what was happening with us is when we were in a vehicle leaving the airport, and we're both just completely just falling apart, wondering what's going on, what's next. To say what our exact emotions or thoughts were at that time, we were just trying to just console each other. Hold on. That's all we had was each other.
Were you all communicating with Mr. Baez during that period of time?
The only time I can remember we talked to Mr. Baez was later that evening.
In fact, you and your wife had
Overruled?
you and your wife had dinner at the Ritz-Carlton that night with Mr. Baez. Isn't that correct?
Yes.
May we approach?
You may. You may proceed.
Mr. Anthony, during the period from July 16th through December the 11th, Mr. Baez asked you about how you cooperated with law enforcement, and you said that you did.
Yes.
Did you also cooperate with Mr. Baez?
Yes.
Did you cooperate with anybody that you thought had the remotest chance of helping you find Caylee?
Yes, sir. I would take any help that I could get.
And January 20th, that was the day after it was declared that the body from the woods was in fact Caylee,
I
isn't
just
it?
want to object. Assumes facts not in evidence. It's January 22nd,
Sorry.
not the 20th.
I'll rephrase.
Sustain.
It was December the 19th that the ID was confirmed. Is that correct? I may have said January by mistake.
Yes, sir. It was probably the 19th or 20th, yes.
So what I'm getting at is this anger that you were expressing toward law enforcement was the day after you had final confirmation that in fact your granddaughter was dead.
Yes.
No further questions.
Read the record.
Mr. Ashton had asked you that you were taken from the car to the Ritz-Carlton. Is that correct? Do you recall that?
It was either car or SUV. That was irrelevant. That's the irrelevant one. But yes, we were taken from the airport to the Ritz-Carlton, yes.
That wasn't by law enforcement, was it?
Whoever it was, I really don't know. I honestly still don't know to this day.
The people who paid for you to stay at the Ritz-Carlton was Good Morning America, wasn't it, sir?
Relevance.
This was brought out by counsel.
Relevance.
Overruled.
I don't know exactly who paid for it. I really seriously don't.
You have no idea. You got to stay at the Ritz for 3 days, and you have no idea who was picking up the tab.
Objection asked and answered.
Sustain.
And did you have to do anything in exchange for that stay, at that 3-day stay at the Ritz, like grant any interviews?
No, sir.
Have you, since then, been on that program?
I don't believe I was ever just on Good Morning America. No, sir.
You've never been on since then?
I don't believe we were ever, I just was on Good Morning America. No, sir. I don't believe so.
No further questions.
May Mr. Anthony stand down?
As the state's concerned, yes, sir.
Thank you, Mr. Anthony. You may stand down, sir.
Thank you, sir.